Hello everyone. Today's topic is about same-sex relationships and how they work with respect to sponsoring your partner in Canada for immigration purposes. I often receive questions about spousal sponsorships and how people can bring their same-sex partner to Canada. And in this video, I'll be providing some context and an overview of how you can bring your partner to Canada and what happens if your country does not recognize the marriage. Now, before we start, I want to do a quick dive into the history of same-sex relationships in Canada and how they relate to immigration context. This all started a little bit before, but in 1978, when the Immigration Act came into effect, the ban on LGBTQ+ immigrants was lifted. This was a significant step forward as members from other nations were able to seek protection within Canada. In the 1990s, sexual orientation was added to the Canadian Human Rights Act, and the Supreme Court of Canada ruled that provinces could no longer discriminate based on sexual orientation. Now, with the introduction of Bill C-38, what was termed the Civil Marriage Act in 2005, same-sex couples had the legal right to marry all over Canada. This made Canada only the fourth country in the world at the time to legalize same-sex marriage. Now, while that was almost 20 years ago, it was a significant time in history and much has changed, with over 34 countries now worldwide that have legalized same-sex marriage. Okay, so that's the context from the Canadian perspective. So that's how we get to this topic. So let's talk more specifically about immigration and how it relates to same-sex sponsorship for under the spousal class and under the family class. Are you able to bring a same-sex partner to Canada? The short answer is yes. The Canadian government and the Immigration Department will not deny an application of same-sex applicants. Same-sex couples follow the same process and procedure as an opposite-sex couple if their relationship is legally recognized in the country of origin. If your relationship is not legally recognized by your country of origin, then a conjugal relationship may be necessary. IRCC, or the Immigration Department, states that a marriage that took place outside of Canada means a marriage that is both valid under the laws of the jurisdiction where it took place and under Canadian law. This means that a Canadian citizen or PR can sponsor their same-sex partner if the marriage is legally recognized in the country of origin and under Canadian law. So, if you're planning to immigrate to Canada as a same-sex couple, it's important to do your research and understand the requirements before submitting your application. I've had a few people come to me over the years and tell me that they were married, but the marriage certificate that they have is not legally recognized in their country. And thus, while there may be a celebration and a beautiful ceremony, it's not something that can be used to immigrate to Canada. Some factors to consider when applying for a spousal sponsorship include: firstly, gather all the necessary documentation. You're going to need to provide such things as a marriage certificate, obviously, passports, police certificates, and any other requirements as per the checklist and basically where the country that you're in. Most importantly, you must prove to the officer and supply evidence of a genuine relationship. You need to demonstrate that you and your partner have a mutually exclusive and committed relationship to satisfy what everyone needs to show to be classified as a bona fide relationship. This can be done by providing photographs, emails, letters, and other documents showing mutually exclusive and a committed relationship. And it goes without saying that it's essential to be honest in your application. If you provide false information, your application may be rejected and you may be barred from misrepresentation, even if it's an innocent error or one that you might have some reason to hide. A valid concern when it comes to same-sex relationships in the country of origin is if your country does not recognize same-sex relationships, you can still immigrate to Canada if you can prove that you're in a conjugal relationship. Now, a conjugal relationship is not set out in IRPA, but factors to establish the relationship include shelter, sexual and personal behaviors, services, social activities, economic support, children, and societal perception. When assessing a conjugal relationship, the visa officer may look at the inability to live together due to the persecution or in any form of penal control. This applies in cases of same-sex couples who cannot live together, as the couple may have a due fear of persecution. There are requirements in place for foreign nationals and their sponsor to provide evidence of their conjugal relationship, which has been ongoing for at least 1 year. So, as you can see, Canada has made significant progress in protecting LGBTQ+ rights and same-sex couples who can immigrate to Canada and follow the same process as opposite-sex couples. If your country of origin does not recognize your relationship, a conjugal relationship might be an option, but it's important to know that there's different options available for permanent residency. However, I will warn you that a conjugal can be complicated, and it's something that you want to certainly go into and make sure that you can thoroughly document and you have articulated it very well within your application and provided the context. Anyways, listen, we're going to wrap it up there. I hope you found this video helpful, and don't forget to like, subscribe, and turn on notifications to my channel for more helpful tips and strategies for immigrating and settling to Canada.